Hey folks, welcome back to the Edupedia world, and I am Abhinay Gupta. And today again we are continuing with the Professional Ethics by the CA Act 1949. So in the previous lecture we were continuing with the clause number 9, right? So we had discussed the text of the clause, the various sections that are applicable, and also the various guidelines that had been issued by the council. Right? For what purpose? For the purpose of ascertaining and what are the cases and how is the new auditor or you actually going to how are you going to ascertain the entire scenario? Right? How are you going to ascertain that the company abides by this provision of the clause? Right? So we had seen in detail about the various situations and conditions, and there were, I think, one or two topics, very small one, which were remaining. And then today we will move ahead to discuss about the committee, right? There is one specific committee that has been established by the council. We will discuss about that committee. We'll discuss one or two case studies and wind up the lecture, right? So if you remember, when we were talking about for example, the mode of notice that for the general meeting that you have to send, right? We discussed that the registered post acknowledgement due is only to be sent, which is a compulsion to the outgoing auditor, right? If the company is giving the notice to the members, that is not compulsory. They can go ahead with any other mode of communication, right? We did those things in detail. Now, apart from checking those notices and the formalities, whether they have been complied with or not, apart from that, the auditor will also need to check the copy of the relevant minutes of the general meeting, right? But which general meeting, to be specific? The general meeting where the resolution for his appointment has been passed and that it has been verified by the chairman or the person who is chairing that meeting, right? And that should be always obtained by the incoming auditor. That okay, if you are appointing me, there has to be a resolution passed, right? Just give me a copy of the minute of that resolution, because you know that your appointment is valid. You have duly been appointed by the members, right? So first you check the notice, you check the removal, and now you're checking your appointment resolution, right? Now we have to discuss about the committee. So the council guidelines for the committee. Now what is the committee? What are the guidelines? I'll discuss about that. But yeah, there's one more case, right, which you as an incoming auditor, right, should check, or there's a case on which you can be twisted in your examination, right? Now they say that the notice has to be sent before the meeting. So this case basically does not necessarily reflect only to this clause, right, but it's a general case. Now what if there was a general meeting held where the notice for the appointment or removal of auditor was not passed, and then the meeting got adjourned? And before that adjourned meeting, they also send a notice now. They're okay, in that adjourned meeting, let us discuss this case. Do you think that will be valid? The answer is no. Right? The auditor has to see that yes, if I have been appointed or the previous auditor has been removed, then the notice for the same had been issued 14 days prior to the general meeting. And when we say 14 days prior to the general meeting, it always reflects to the original meeting. It has nothing to do with the adjourned meeting, because adjourned meeting is not predicted, right? That is not a meeting which was actually called and planned. If the decisions are not being able to be compiled in the original meeting, then the meeting may be adjourned for the same day, same time next week. Right? But when you call a meeting for a particular discussion, that is always the original meeting. Right? So the notice has to be sent 14 days prior to the original meeting. Always make sure to ascertain this. Right? And after you have done all these things, after you have been satisfied and after you have ascertained that yes, the company has followed the provision of section 139, 40, 140, 141, 142, then when you are satisfied, then you send your intimation to the outgoing auditor or the previous auditor that yes, everything over here is checked. I am going to take up the engagement. I'm just writing a communication to you so that you let me know if there is any problem or the reason why you left. right? Should I take up the appointment or not? Is there anything you want to warn me for? So that notice now you will send after this. So clause 8 falls after clause 9. So the procedures as per clause 9 has to be first complied with, and then you go back to the procedures as per clause 8. Right? And then again remember that this notice has to be sent, yes, by a registered post acknowledgement due. Okay? Now there also may arise a lot of ethical issues, right? During all these, like taking up the appointment and not informing or not ascertaining, there are many issues that may come up. So to deal with these issues, right, the council had set up an ethical standard board that will deal with all the ethical issues, right? Now this committee has been given the responsibility to see whether the professional ethics have been complied with in all cases. Either maybe because somebody has raised an objection for it, somebody has informed you about it, or seeking to the importance of the case, they may take up the case to judge and see whether the ethical issues have been resolved, right? And this same committee is also charged with the responsibility of looking into the case of removal and resignation of auditors, right? The committee who has been given the overall ethical responsibility, that committee has also been charged with the responsibility of appointment and resignation of auditors. So now the council has also issued certain guidelines for these committees as to how are they going to look into the case of removal of auditors. And now we are going to discuss that, right? What are the guidelines that have been issued to these committees? The first instance is if the auditor resigns. So basically so far actually we have seen the various instances that the auditor has to check with regards to section 139, 140, 141 and 142, right? Now there are certain more things, right, that are required by the auditor to be checked. Understand what I mean to say? Like what happens is when the auditor resigns, or for example when the auditor does not offer for reappointment. Obviously at the end of the year, auditor will resign and be reappointed. He does not offer for reappointment, like I don't want to be reappointed. Then there has to be an issue. Why are you resigning? Why are you not being reappointed? Why do you want to leave the company? Now if there is any reason, right, if there is any professional reason behind resigning or behind not taking up the appointment again, then don't you think that the auditor has to inform or send a notice to the board of directors? Yes, he has to, right? So if there is any professional reason why he wants to resign, he'll have to send a notice to the board of directors. And similarly, he will also have to inform the institute, right? If there is such professional requirement, first of all, he brings it to the notice of the board, and then he also sends a copy to the institute. Now, this is again one more place from where you can understand the reason why he left. Instead of, like in clause 8, what you do is you send him a communication and ask him for that reason, right? Now this is one more place from where you can get that reason. He must have given a notice to the board of directors. So you as an incoming auditor, before you accept any appointment, right, you should obtain the copy of that communication that happened between the outgoing auditor and the board of directors. Take that copy, examine it, and then see whether there is any case, whether there is any reason that would suggest you or that would compel you not to take up this appointment. If there is, don't take it. If there isn't, you can go ahead. But this is one again step that you should check. But that does not mean that if you have checked the reason over here, you will not communicate to the previous auditor. So clause 8 remains where it was. At the end of the day, you have to communicate before taking up the audit. But there is a lot many chance that the reasons given by the incoming auditor for your communication as per clause 8 would be the same as per the communication made with the board of directors. But still, it may be. It is not compulsory. Maybe he tells you some other things as well. that he may not have shared with the board of directors. Like, I'm telling you a practical scenario, anything can happen, right? That is why both the requirements have to be fulfilled. Yeah, these are getting into some more details and nitty-gritties, but understand these are all the ways how you can ascertain. Ascertain is the word, right? Now there can be one more case. If he has left, if the previous auditor has left the office and you are being brought in, you are the incoming auditor, he was the outgoing auditor. So one thing is either he resigned, he went out. Second, he did not take up the reappointment. Third, although he wanted to be reappointed, company did not accept him. Company did not reappoint the auditor. Now in that case, again remember, if you go back to the law, if the company does not accept the reappointment of an auditor, then the auditor is given a chance to make a representation. Remember, before outgoing, he makes a representation to the members. Either it is circulated to the members or read out in the meeting, whatever happens. Remember those things in the law? So again, that is one more document, that auditor's representation letter, that you will find with the company. Although one copy of it has to be submitted with the institute, but you cannot go to the institute to ask for it, right? So you will have to obtain a copy of that document as well from the company, right? Even that is your responsibility now. So take it, go through it, and then again decide. Again, because I'm always focusing on the word, you have to ascertain, right? I know none of you are going to forget this word now. Clause 9 is crisp, clear in your brain. The name of the sections, the terms, and that you have to ascertain that the company has followed these sections, nothing else, right? So these are the three cases we have seen. Now what is the role of this committee? Now after you have done all these communications, after you have made all these communications, the council, if it wants to get in to detail inquiries, it can call for more information from the outgoing auditor or the incoming auditor or the company and prepare a report on it, whether all the things have been complied, whether the ethics have been followed, where and not the ethics have been compromised, if any, and everything, right? And then it will prepare a report and give it to the council. But it is only in case it deems it necessary. It is not necessary for it to prepare that report always. But if it thinks that no, there is a chance of an ethical compromise, it may go ahead to gather more information and get into the details of the matter. Again, there is one googly in the examination that you need to be aware of, that if they mention that the removal of auditor is the case where the auditor was removed by the government or any other statutory authorities, so what? The documents will be there, right? The auditor will have made the representation, anything. So when these things happen, the communication from that government department has to be there, the communication from that authority has to be there, then the response of the auditor has to be there. These all documents will be present with the company. You have to take them and ascertain whether everything is correct or not. It's as simple as that, right? Now, if you people, if you have the new study material or you go online and check the new study material, then at the end of this clause, there's a small para given, right? As I always told you that, yeah, it's better that you go on with writing both the sections from both the Companies Act. You make a reference, it just takes 2-3 seconds extra. But if you still don't have time in the examination, then do not write the previous section. Instead, you are suggested to write the new sections 139, 140, 141 and 142 from the Companies Act 2013, right? And once the CA Act 1949 is amended to be in parallel with the Companies Act 2013, everything will fall in place. But unless and until it is amended, right, you can follow this. But again, the problem is, Institute has given a guideline. It is not compulsory that the person who is checking it is aware of it. So on the safe side, I still recommend write both the sections and specify that both the sections are from two different acts. Remember the number 224 to 24A to 25, 139, 140, 141, 142. That is it. I have been repeating it over and over again in the previous 2 lectures as well, so that it seeps into your brain. It is into your head. mention the section and mention it from both the act. That is recommended on my end. Otherwise, even there's an institute recommendation where you can only write about the new section. Right? Now after all this, we have already come to the end of clause 9. But there are 2 case studies that I'll discuss with you. Now just see the beauty of how clause 9 will actually come into play in the answers. Now for example, what happened? There was a chartered accountant, Mr. X, who was supposed to be appointed in the general meeting, right? But due to some or the other reason, that appointment was declined, right? Declined by Mr. X. That means Mr. X was actually appointed, but Mr. X declined that I will not take up the charge as the auditor of the company. Now what did the board of directors do? They appointed CA Y as the auditor in place of CA X, right? And then CA Y accepted it and they carried on. Now this is the case, this is the question. Now, what are the things that you feel has gone haywire in the entire scenario? Number 1, board of directors are allowed to appoint the auditors only in case of the casual vacancy. But since Mr. X did not take up the appointment at all, the office remains vacant. It is not a casual vacancy. It is not yet filled. Had Mr. X accepted the appointment and then resigned, then it would fall into the category of casual vacancy and the board of directors could have appointed Y. But since he did not accept at all, it is not a case of casual vacancy. So first of all, what is the flaw? The board of directors were actually not entitled to appoint CA Y. Right? Number 1. Then what was the right thing that should have happened? That if any auditor is not appointed in the annual general meeting, then the existing auditor continues. Right? There's no vacancy. The existing auditor will continue. So if the existing auditor was Mr. P, Mr. P will continue. Why will you appoint Mr. Y? Getting the point? So these were the 2 statutory default on the company's end. Now what is the default at the end of the chartered accountant CA Y who has taken up the appointment? So as per clause 9, that chartered accountant will be deemed to be guilty of professional misconduct because he did not ascertain from the company whether the requirement of section 139, 140, 141, 142 have been fulfilled. Did not ascertain, right? Because he should have taken the documents, verified, checked and everything like we have discussed in the entire 2 lectures. And if that CA would have taken the documents and verified it, he would have come to know that yes, the appointment is faulty and the provisions of the sections have not been complied. But he did not ascertain it and took charge, right? Accepted the appointment. So he is deemed to be guilty of professional misconduct, right? So you see, there is a default at the end of the company that is separate. And then there is a default at the end of the chartered accountant. That will fall under the category of clause 9. Got the point? Now similarly, you can take up another case. There was a chartered accountant, Mr. X. There was a director in the company, Mr. X, right? And his wife, Mrs. Y, was a chartered accountant. And what happened is, the company appointed Mrs. Y as the auditor of the company. Now what will happen in this case? Number 1, the company is at default. Why? Because the auditor cannot take charge, or the CA cannot take charge as an auditor of a company in which the spouse is a director. If I say in the technical term of law, then a person shall not be eligible for appointment as an auditor of a company whose relative is a director. That is actually the statement. So over here the spouse was a director. So Mrs. Y is not eligible for appointment. Right? Now what happened? The company is at default. It's a statutory default that you have. How could you appoint Mrs. Y? That is the default at the end of the company. But now Mrs. Y is guilty of professional misconduct as per section 9. As per clause 9. Why? Because she did not ascertain that the requirements of section 141 was fulfilled. Because section 141 that talks about the qualification, disqualification and the appointment things, right? So over there, if it says that if you're related with the director, you cannot take up the position of an auditor, but you still did, that means you defaulted. You did not ascertain with the company whether the requirements are fulfilled. You knew you could not, but you went ahead. So you will be guilty of professional misconduct. Right? So that is all about this clause, the clause number 9. And if you refer to your study material, there are 2 decisions of the court that has been given. Right? In the first case, what basically happened is a chartered accountant took over the charge but did not communicate with the retiring auditor or the outgoing auditor. Right? So he was deemed to be guilty of professional misconduct as per clause 8. But when it was taken to the High Court that it was a mere technical fault, it was not intentional, then High Court just lessered the punishment than the removal. So he was not removed, but he was actually punished with some other things. So that was a case that happened. The case of S.V. Karwandakar versus O.K. Borkar. It is not necessary for you to remember the case studies, the names, but I'm just giving it to you. Right, that you know, yeah, certain case like that happened. So it's a practical scenario. In that scenario, he was not removed, but a lesser punishment was granted. But for you, you know that yeah, he's supposed to be removed. Right? And then there was another case where there was an advertisement in the newspaper. The chartered accountant went, the director took him in, and the chartered accountant did not communicate, plus did not ascertain anything. So he was deemed to be guilty under clause 8 and clause 9 both. And this was the case of B.N. Mohan versus K.C.J. Satyavadi. Right? So with that, we come to the end of the entire clause. We have covered every single thing. The text, the procedures, the case studies, right? The council guidelines and all of those things. And now I think the clause number 8 and 9 are crisp and clear into your brain. Anything from anywhere can be handled by you. Right? If you have any query regarding what we have discussed, share it in the comment box below. I'll be very happy to respond, but the query should be relevant. Don't bring out some case studies or some cases, some hypothetical examples, right? That will be confusing other students as well. But whatever I have told you about this, that is all the information that the institute wants to communicate. You may or may not be receiving such information in the books of all the authors. So recently somebody asked me in the comments which book to refer. The best book that you should be referring for any subject is the study material. It's as simple as that, because that is what the institute wants you to know and that is where the questions come from. So why do you bifurcate and filter it in the other notes that you follow? So it's straight and simple. The institute study material and practice manual are really very good. Follow it once and try it. Right? So on that note, I'll leave you guys and we'll see you back with the next lecture about clause 10. And then there are just 2 more clauses to be done with this entire part. Right? So see you guys back in the next lecture. Until then, it is Abhinay Gupta signing off. Thank you and bye-bye.